Again, good afternoon, everyone, and welcome to today's webinar. My name is Michelle Peterson, and I'm the Training Manager for the Empire Justice Center. First, I do need to note that today's webinar is made possible by the New York State Attorney General Homeownership Protection Program and in partnership with Legal Services NYC. Before we get started, just a couple of notes on how you can interact with us. Everyone has entered the webinar in a listen-only mode, so if you have any questions on any of the material that's being presented during the webinar, you can enter your question using the questions pane located on your control panel. We'll be addressing questions at the end of each presentation as well as at the end of the whole presentation. Materials for today's webinar can be downloaded by going to the handouts pane on your control panel. Here you're going to find 3 copies of PowerPoints and the attorney affirmation form for any of you seeking CLE credit. Today we're going to be providing 1 credit in professional practice. To receive your CLE certificate, you need to note your verification code on your form when we announce it and send your completed certificate to my attention. You can either send it by mail or you can email it to me as well. We'll also put the CLE code in the chat box, which is also located on your control panel. For any non-attorneys that are attending, we can provide a certificate of attendance. So you can email me directly requesting your certificate, and I'll get one out to you. And at the end of the webinar, you're going to be asked to complete a webinar evaluation. As always, if you could take a moment to complete that, we would greatly appreciate it. So with that out of the way, I'm going to turn it over to our moderator, Becky Keiko.
Thanks, Michelle. So today's topic is really a bit off topic than we normally do, where we're normally focusing on what are we handling within our foreclosure cases, the folks that we represent directly, and how do we fix the problem, right? But part of our job, as you know, is the counseling component, and many times we will take on a case, we'll fight the good fight. Sometimes the homeowner decides they're all done, or perhaps we've lost at summary judgment motion, or whatever may have happened. And now there's a lot left of the foreclosure that we don't necessarily have our hands in, but our homeowners are still going to have to go through that process. And it would be really helpful, and in fact it is really helpful, to offer that bit of advice to our homeowners and our clients so that they feel confident in what it is that they're about to go through and face potentially on their own at that stage. So this is not for what you may be covering at your own desk in terms of actually fighting it any longer. This is beyond that stage. And this is really what are the procedural steps after all of your motions have been filed and you're out. So with that, we have 3 experts from around the state, and I'm happy to introduce them and happy that they have been willing to participate in this. Lynn Armentrout with Brooklyn Legal Services, Marlene Morales with Legal Aid Society of Northeastern New York, and then starting us off will be Fiona Wolf here at Empire Justice Center. So without any further chatting, Fiona, would you like to get us started?
Hi there, everybody. Thanks, Becky. Brief introduction. I've been at Empire Justice for about a year now, but before that I spent about 6 years actually working on the plaintiff side, so doing foreclosure actions for banks throughout the state. So that's really my background, and that's why Becky asked me to participate in this webinar and just really, like she said, give some practical information about the procedure from the other side. So I'll just jump into my presentation. Here we go. So you've fought it out at settlement conference, and for one reason or another, you've been released from conference. So what does the bank attorney do next? Well, the first thing they're going to do, they're going to report back to the bank immediately, let them know that they got that release. They're also, really the same day, they're going to request an affidavit from the plaintiff. Now, I've got down there on the slide, affidavit of merit, amount due, or indebtedness. Those are really all different names for what is essentially the same document. Different banks, different services use different names. But the important thing is that they're going to have to get their hands on this original affidavit from the plaintiff before they can take the next procedural step. What should you be doing at that point as the homeowner's attorney? Well, definitely keep an eye out if you've been released from conference with perhaps a stay in the proceedings. I know that that can be quite common in the court up here in Monroe County anyway, and certainly in some of the other counties. definitely mark your calendar. Watch out for banks moving too early. But I think probably most people have the same experience that we have up in Monroe here, is that it's unusual for banks to move too early for a variety of reasons, but I'll touch on that later. But definitely mark your calendar for that. So what procedure is the bank going to follow? It's going to depend whether or not the homeowner has filed an answer in the action or not. If no answer has been filed, the bank's going to move. They're going to bring an ex parte motion for the appointment of a referee to compute, or as it's more commonly referred to, and as you probably hear it referred to more often, is a motion for order of reference. They're going to have to get ready their supporting papers for that motion. I mentioned that they're going to need an affidavit from the plaintiff that they will have already requested. And then the bank attorney is going to start preparing their own affidavit in support of the motion. Sometimes that's referred to as an affidavit of regularity. So you may see it titled different ways, but it's essentially the same document. And they're also going to be collecting their exhibits that they'll need in support of the motion: the summons and complaint, affidavits of service, and any notices of appearance or waivers. So that's their sort of first step, what they're gathering if they're doing the ex parte motion. If the homeowner has filed an answer already, if there's an answer in there, slightly different procedure. The bank's going to have to bring a motion for summary judgment. They're also going to be looking to dispose of the answer and to appoint the referee as part of that single motion that they're going to bring. Now, there's obviously been a lot of trainings and webinars and things about summary judgment motions. I'm not really going to spend any time talking about it in any particular detail, but let's just assume that the bank's going to succeed on that motion if there's no triable issue of fact, if those defences lack any merit, counterclaims don't give rise to any cause of action. I think let's assume then that the homeowner is putting kind of a general denial answer. That's the sort of thing we're talking about here. So as Becky mentioned at the outset, we're not really going to get into any challenges or any opposition that the homeowner is going to bring to the summary judgment motion at this stage. Let's just assume it's a really straightforward summary judgment motion that the bank's bringing. Again, they're going to need supporting papers that they'll be preparing, an affidavit of the attorney again, they're going to be pulling together their exhibits, memorandum of law, because it is a summary judgment motion that they're bringing, and again, they're going to need that affidavit from the plaintiff. So is there any practical difference for the homeowner, whether it's an ex parte motion or a summary judgment motion? In that situation where you have a homeowner that's just put in a general denial and they're not contesting things any further, really there's no practical difference. Not much practical difference for the bank attorney either. A little bit more work involved if they're going down the route of a summary judgment motion. So I suppose something that I should mention is that if that's what's happening, if that's the next procedural step, the bank attorney will be requesting and will be approved for additional fees from their client if they're bringing a motion for summary judgment. If it was an ex parte application for order of reference, that fee is normally wrapped up in the standard fee that they're getting for the whole foreclosure action. So the homeowner is going to likely see a large additional fee, perhaps in the region of about $1,000 or more, being added on if it's a summary judgment motion route that the bank's moving in. Just something to bear in mind there, or something maybe to explain to your homeowner further down the line. Okay, one of the things that seems to come up quite often, certainly in our county, and really as far as I'm aware throughout the state, is that it can be quite slow. There seems to be a bit of a delay between the release from conference and the bank bringing one of the motions here to get their order of reference. Certainly very normal for plaintiffs' attorneys to appear at the calendar calls and status calls that we have and really request more time from the court to take that next step to move forward with their action. And quite often people want to know why. The homeowners want to know, why is it taking so long? Well, a lot of the delay does lie with getting that original affidavit from the plaintiff that the bank attorney is going to need, whichever direction they're going in.
Hey, Fiona.
I wish I could explain to you why it takes so long.
Fiona?
Sorry, Ben?
Sorry, Fiona. So apparently it went out a bit for some folks. Could you just repeat maybe the last point about how long and very specifically how much more time, if you can get into that detail?
About how much more time the bank attorney needs, is that what you mean?
I think so, yes. So the audio went out for a moment, apparently, that people missed some of it.
Oh, sorry about that. I was just really explained that there can be quite a long delay, oftentimes, between that release from conference and the bank bringing their motion for order of reference. And a lot of times, I think homeowners want to know, why is it taking so long? They've been told the action is going to move forward. Why is it not moving forward? And a lot of that delay is because it takes a long time for the plaintiffs, for the banks, to get those affidavits over to their attorneys that will let them bring that motion. As I mentioned in kind of my first slide, the day that you're released from conference, the bank attorney is requesting that affidavit from their client. I wish I could explain why it takes so long for the banks to get those documents executed and back to their attorneys. My experience, there just seems to be no rhyme or reason as to which ones they choose to execute quickly and which ones sit in a pile somewhere on someone's desk. It would be fairly normal for us to have to appear at sometimes multiple calendar calls and just really ask the court for more time while we wait for those executed affidavits. They're standardized documents. The bank has really had a lot of input in them. They're really just filling in the blanks, so there really is no explanation as to why it takes so long. It just does. There are normally procedures for bank attorneys to escalate those requests, but again, I don't know why they take so long. They just do. Something else that can certainly hold up the process would be if you have a change of the plaintiff or the servicer during the conferencing stage. Now, sometimes you can be in conferences for a long time, and that's fairly common to have that servicing change happen. That's going to hold things up as well, because the bank attorney is also going to need to get hold of the assignment of mortgage, if that's necessary. Maybe that has to be prepared, executed, recorded. So that'll all have to be done before they can bring their next motion. So that's just going to add into the length of time it's going to take them to move forwards. If there has been a change of bank, they're going to have to bring a motion to substitute plaintiff and to change the caption as well. Now, I'd say 9 times out of 10 they're going to wrap that in. They're going to bring it as a combined motion for order of reference rather than introducing a whole other motion practice into the timeline. But just something to bear in mind. If there's a servicing transfer, that's an explanation you can certainly give to your client as to why it's taking so long to move forward. Okay, so the motion for order of reference. What is the bank actually asking for? Well, you're asking the court to refer the action under RPAPL 1321, and they're going to ask the referee to ascertain and compute the amount due to the plaintiff, and also to examine and report whether the mortgage premises can be sold in one parcel. That second one, it's kind of like the lesser of the two. If it's one tax ID number, if it's just one property, one parcel, that kind of goes without saying. For residential foreclosure actions, I don't think I've ever seen one where the referee has not reported that it can just be sold in one parcel. So it's really the first one, is to ascertain and compute the amount due to the plaintiff. Also, at the time when they're bringing their motion for order of reference, the bank attorney is also going to ask the court to amend the caption, to delete any John Does and to add in any tenants that they've identified while they've served out the summons and complaint at the start of the action. So sometimes you'll see that added in the motion papers, but that's just a purely procedural step. So turning back to the motion papers, just a little bit more detail about what they're going to put in there and what you're going to see once that large set of papers arrives on your desk. For both ex parte and a motion for summary judgment, the plaintiff's going to submit their own attorney affirmation in support of the motion. That's really just a kind of factual set out. They're just going to narrate all the facts so far, starting from summons and complaint, service of all the defendants, time to answer expired, and they're also going to narrate the participation and release from settlement conference. They're also going to have to collect, and I know I keep talking about it, but that affidavit from the plaintiff. So what that's going to cover sort of the other side of things that they need for this motion. It's going to be normally done by, well, it's going to be somebody with authority from the bank, and they're going to be narrating that they've reviewed the business records relating to the specific loan. They're going to basically cover their personal knowledge of the loan. They're going to cover possession of the loan documents. Presumably the originals are with the bank, and they'll be stating that. It's going to cover all the details of the homeowner's default, plus the notices of default that the bank has sent out, and the 90-day letters, and all of those be exhibited as well as part of these. And the bank attorney is also going to draft up really just a standard order of reference that they're going to present to the judge as well, so that hopefully, well, I say that talking from my old job, but they just want to present a nice, concise picture to the judge so that they get their order of reference signed off quite quickly and get their referee appointed. So the judge gets the whole application, they get everything all in a nice, neatly stacked bundle from the bank's attorney, and in the absence of any opposition, they're likely going to be appointing a referee fairly quickly. The referee that's going to be appointed will be an attorney that's registered, already registered for appointment as a referee under Part 36 rules. And the referee, like I said, is going to determine the full amount owed by the borrower to the lender. They do get a fee for the computation. $50 to $250 really seems to be the normal range. The specific fee is going to be set by the judge, and it's going to be set out in the order itself. So you'll see how much the referee is going to be paid for the work that they're going to be doing. The referee that's appointed to compute in the order of reference is, 9 times out of 10 going to be the same referee that's going to sell the property at auction. The only reason there'd be a change of referee would be if the referee retired or for some other reason had to sort of decline the next appointment. But it's normally always the same referee. And when it comes time to sell, they're going to get some more money, normally about $500 or $750. Again, that'll be specified in the final judgment. So we've got to the point of a referee being appointed. I don't know if I should pause now, Becky, and if there's any questions, happy to take any.
Yep. Is that an hourly rate?
No, it's a flat fee.
Okay. And another question, there's a lot of money questions today. How much did you say it was possible for additional fees to be added to the lump sum after a summary judgment if the bank has to file a summary judgment motion?
That's a good question. I mean, that really is between the bank attorney and the bank. I can speak from my own experience. The way we would ask for our additional fees is we would have to give an estimated number of hours that we thought it would take us to review and respond to all the issues that have been raised in the answer or counterclaims, and quote an approximate fee. Basically just submit an additional fee request to the bank, and then it's for the bank to approve or deny.
Okay. I think there was some.
So you might see that, and if you're getting reinstatement, if you're getting a reinstatement quote after there's been a motion for summary judgment, you're going to see additional fees in there that relate to the extra work that the bank has carried out. I mean, a rule of thumb to dispose of a general denial is should be a lesser additional fee than to deal with multiple affirmative defences and counterclaims. That just makes sense.
Okay. And then another question, I'm not sure if you know the answer to this. In fact, it's because it's a little different. You may simply not. Did the additional fee, I'm assuming you're talking about, does this also apply to county tax foreclosures? I'm not quite sure, Rosalie, exactly which fee you're talking about. Perhaps the referee. I'm not quite sure. I'm sorry, Rosalie. But there's a lot of questions about how this translates between tax foreclosures, and then there's also a question about surplus motions. Is this an additional fee for surplus motions? Do you happen to anything you can offer, any wisdom on for that, Fiona?
Nothing I can really see in relation to tax foreclosures. I mean, I was talking purely about an additional fee that the bank attorney is going to request for dealing with a contested litigation, pretty much. So they're going to get more money. They're going to get paid more than the standard foreclosure action if they have to bring a motion for summary judgment. That's all I was trying to get across, is that even if your homeowner files just a general denial answer, that's going to incur an additional fee.
Okay, and then another question is, does the defendant have a right to testify at the referee's hearing?
That is a good question. I do have a slide coming up about referees' hearings, so perhaps I should kind of move on.
Sure.
And maybe answer that as we go forward.
Yep.
If that sounds okay.
Yep, and I believe you had something on there about surplus motions as well, correct?
I do, yeah. I've got a little bit at the end about just surplus money proceedings in general, so maybe that'll answer the questions. If not, we can certainly pause for more at that time.
Precisely. Okay, perfect. Let's move along.
Okay, so your referee's been appointed, and now they're going to compute. They're going to compute that total amount that's due to the plaintiff under the terms of the mortgage through a given date. So just really the date that they're going to be doing their report on. Principal and interest, all advances, late charges, and the referee is also going to calculate a per diem rate. The referee also swears an oath of referee. It's a real basic one-page document. You've maybe seen it. Again, it's probably arrived in your desk if you're getting copied in on, various motions from the bank's attorneys. Basically, that's just the referee swearing that they're going to faithfully and fairly determine the questions that have been referred to them and make a just and true report. Okay, oath of referee is just really a formality. The big one is really the referee's report of the amount due. That's going to be pre-prepared by the bank's attorney, and that's going to include all of the calculations of that total amount due. The referee is going to get an affidavit from the bank, and that's going to include all of the documentary evidence really in support of all those corporate advances. So, for example, if there's been any taxes, insurance paid out, they should be seeing that documented in the information that they get when they're preparing. I say preparing, normally pre-prepared, when they're completing the referee's report. Turnaround time, once the bank has its order of reference, the bank attorney will very quickly move to get this full set of papers out to the referee. I would say we were under pressure to get it out within at least 1 week, regardless of how long it had taken to actually get the signed order of reference from the court. It's always expected, if you're working for the banks, that there's going to be a very quick turnaround on any timelines that you, as a bank's attorney, can control. So papers out to the referee quickly, and then normally looking to get everything back from the referee in about 2 weeks. If it went any longer than that and you hadn't heard from a referee, again, pressure would be on to try and perhaps bring a motion to appoint a substitute referee if the first one was dragging their heels. Okay, referee's hearing. We had a question about that. Standard practice really does seem to be that the referee computes on papers only. In the 6 years I was doing this work for banks, we never had any referee conduct a hearing. Everything was just done on the documentary evidence that we would present in paper form to the referee. Now, the order of reference can define the referee's powers, and absent any specific restriction, the referee will have the power to hold a hearing. So I guess the answer to the question is, if you think you want a hearing, request one. Contact the bank's attorney, let them know that you want to have a referee's hearing, you want to have an evidentiary hearing before the referee. That, I believe, is an option to any homeowner if they so choose. Also, the court can decide at the time when the bank's moving to confirm the referee's report, the court could decide that they ought to have a new hearing held before the referee. So if there's anything that you think ought to be challenged, if you want to challenge the accuracy of the report, you can certainly do so. I don't know if that's a sufficient answer to the question that was raised, but that's probably the best I've got.
I think that works for now, Fiona.
Okay, thanks. So after the referee has, and like I said, standard practice, just signed off on all the paperwork that's been sent to them, everything goes back. They'll return their oath and report back to the bank's attorney. And then the bank's attorney is getting ready to bring their motion for judgment. Okay, so they're going to submit the oath and report to the judge. Firstly, they've got to get that confirmed. So that's part of the motion for judgment, is to get the oath and report confirmed. So like I said, if you are wanting to challenge, you could certainly oppose the motion for judgment on the basis that you want to challenge the accuracy of the report for one reason or another. bank attorney is also going to prepare another attorney affirmation. They're going to set out the facts of the action again, but they're going to update it and bring it through the point of having the referee appointed and that the referee has now computed the total amount due per their report that's been submitted. Bank attorney is also going to prepare a bill of costs. Now that allows an award for costs and disbursements to be included in the final judgment, and they're going to prepare the proposed judgment and send everything again in a nice neat package over to the judge in the hope that they'll get a quick sign off. At the end of the slide there, I've just sort of set out how you'll normally see it. That's a very summarized version, but you'll have, judgment of X amount plus the interest from the date of the referee's report, X amount as taxed by the court for fees and costs and disbursement, and then an additional amount under 8302, which is really just a statutory additional amount that you're allowed in a foreclosure action. I believe it caps out at about $200 to $250, something like that. What I haven't put on the slide there is that the bank attorney might also have to renew the notice of pendency. If for any reason that is, you've gone 3 years, if it's been a long-running foreclosure action, they'll have to renew the notice of pendency and submit that as well. Timing-wise, some judges are slow, some counties are, but once everything's with the judge, it really just is a matter of time until that's signed off and you've got final judgment against your homeowner. So once the bank attorney gets judgment, what do they do next? Well, firstly, they're going to contact the referee and they're going to set up their sale date. They're going to have to prepare a notice of sale. Again, everyone's probably seen these. Homeowners come in with them all the time. Sets out property description, date, time and location of the sale, the judgment amount, and the referee that's going to be conducting the sale. Your homeowner should get a copy of that, should be mailed to them by the bank's attorney, and also any appearing third-party defendants, and really any does as well. Any tenants of the property should be getting their own separate copies of that notice of sale. The notice of sale has to be published. The judgment will specify the newspaper that the publication has to run in. There are 2 different options. They can either publish twice a week for 3 weeks or once a week for 4 weeks. And then there are sort of designated dates upon which the sale must be held after the first date of publication. And it varies slightly depending on whether you're looking at a twice a week or a once a week. This is all kind of real technical stuff, but this is what the bank's attorney has to address in the weeks running up to the sale. There may also be a requirement to post the notice of sale. Now that only kicks in if your property is not wholly located within an incorporated village or a city. If posting is required, that has to be carried out at least 28 days before the sale. And the notice of sale will just be publicly posted. It will just be pinned up in 3 public locations in the town where the property is located and the location where the sale is being held. Because that is a little bit technical, oftentimes banks' attorneys will post regardless of whether or not it's technically required. They just cover themselves. So again, you're probably going to see a little cost in at the end there for posting, even if it wasn't strictly necessary. But in the grand scheme of things, you're probably looking at $100 to $150, so it's not really a tipping point there. If there are any mistakes in these technicalities, I mean, I suppose homeowners are going to want to know, can you try and get the sale set aside if there are any mistakes? It really depends. Oftentimes, the bank's attorney is going to know that they've made a mistake. It might come up, they might know immediately, or it might come up way further down the line. It might come up once the sale has been held and a third-party purchaser, their title company, might raise it. Or it might come up once this property is over with the real estate owned department of the bank. There at that point, the title review might notice that there has been a mistake in one of these pre-sale requirements. So oftentimes, the plaintiff is going to bring a motion to, amend their judgment, nunc-pro-tunc, or to validate the sale. If it's a procedural defect, then they're likely going to succeed with that motion. To give you kind of an example of a sort of successful motion from the bank, a publication was ran in the wrong newspaper. The notice of sale was published, but not in the newspaper that was directed by the judgment. That sort of thing is likely going to be granted because the question that the court's going to look at is, did the defect prejudice a substantial right of the defendant? If it was published, but it was just the wrong newspaper, well, there's not really much prejudice there to the homeowner. So just something to bear in mind. You could challenge a sale based on one of these technicalities, but you know, toss up as to whether or not it's actually going to do any good in the long run.
Okay, so Fiona, I'm going to pause you here because we have a number of questions rolling and I don't want to lose track of some of these.
Pause anyway.
I'm sorry?
Absolutely. No,
okay.
Go for it.
Okay, so let's see. The first question is, will a borrower receive a mailed notice of sale if he does not file an answer? And I'm realizing that you may be answering that question next.
Yeah, they should. They should receive a copy of the notice of sale. It should go to the property or any known addresses for the homeowner.
Okay. And if set aside, I'm assuming we're talking about the judgment. If the judgment is set aside, will they have to start the process all over again?
I wasn't so much talking about having the judgment set aside. I was just talking about having the sale set aside if there was one of these, I'm going to call it a procedural defect in perhaps the noticing of the sale. No, they wouldn't have to start all over again. They would just have to reset a new sale date. So it would be sort of backtracking to judgment.
Okay. And then only published in one newspaper is the question. Does it have to be a local newspaper, like a village newspaper or some sort of regional newspaper? What's the scope of that?
That will be set out in the judgment. Normally it is always just one newspaper and the judge picks the newspaper. It tends to be that counties will have their newspaper of choice. So for example, here in Monroe, it's the Daily Record, I believe.
Yeah. Okay. So then one other question here is there a statute stating that the homeowner must receive a notice of sale? I've never found one and had assumed that the publication/posting was the only required notice.
I don't think there is a statutory requirement for it, but it does seem to be, pardon my language, a kind of cover your ass thing that all bank attorneys do.
Okay.
So I can look into that.
Okay. All right. That's all I've got, I think, for now. Thank you for listening, Fiona.
No problem at all. Okay, so we're moving on to the sale day. I don't know how many people have been to sales. I'd say particularly if you're new to this, it's always good to go down and watch a foreclosure sale happen, just so you can see how quick the process is, given that it's taken years to get to that point. The bank attorney is going to do a final check for last-minute bankruptcy filings. They do that at various points throughout the process, but always on the morning of the sale. The sale is going to be held by the referee. They're going to read out the terms of sale. They're also going to have a few documents with them ready to be completed if, for example, it goes to a third party. So the receipt, if they're collecting 10% of the bid price from a third-party purchaser. The referee also has to complete a surplus money form that they have to file with us, and that's a real requirement on the referees. That's relatively new. So they'll normally all be looking for that on the day of the sale to make sure that they are signing off on everything they need to do. The banks will always send their own representative to the sale who'll be there and authorised to bid for the bank. A lot of people ask questions about how do the banks calculate their bid. That is another question that I wish I could answer. Sometimes the bidding instructions that we used to get through made perfect sense. It seems like they'd actually looked at the value of the property, where the property was, and made a real reasonable opening bid. Sometimes those bids were just, it made no sense in relation to the actual value of the property. But there you go. The bank attorney will be, the bank representative will be there to place an opening bid for the bank. The referee is also going to complete additional documents after the sale, the referee's report of sale, the referee's deed, and various property tax forms. If at the sale the property goes back to the bank for the opening bid, if there's nobody there to outbid, the deed and report might actually be ready and might be executed the same day, or the bank's attorney might need time to finalise the report. They might be waiting for affidavits of posting or publication, to come in from the newspaper, or page receipts. There's various things that they have to exhibit to the report, so that might just build in a little bit of extra time. I would say normally about 30 days after the sale, if the property's gone back to the bank, you should be at the point of having a recorded deed, a referee's deed recorded. If the property is purchased by a third party at the sale, it's normally 30 days for the closing to happen. That in practice does tend to be extended. Banks don't normally like to go too far beyond it, though. Maybe an extra 30 to 60 days. They'll give a third party to close, but they do want it wrapped up quite quickly. Your third party might also assign on their bid to somebody else, so that can sometimes lead to a slightly longer closing if you're dealing with an assignment. When the third party sale closes, the referee is going to pay various things from the proceeds. They're going to pay any assessments, water rates, all the expenses of the sale, including the referee's fee, will come off the top there. And all those expenses of sale, those filed receipts, will go in with the report that's going to get filed. Then they're going to pay off the amount of the debt, interest and costs, or as much as the proceeds are going to pay. And then finally, if there's any surplus money left, the referee must pay that into court within 5 days after receiving the funds. So I'm about to move on to surplus money proceedings, so if there are any questions, Becky, I'll take them before I move on.
No, I think we're good for the moment.
Perfect. Okay, surplus money. So the referee deposits any additional funds after paying all those expenses. They're going to deposit them with the county treasurer. So who has a claim to that money? Your homeowner's got a claim to that money, but also any subordinate lien holders. So everything I've been doing kind of up until now is really bank attorney's point. This is where you could really get involved for a homeowner. Somebody comes to you, or you've been representing them the whole way along, and you know that there's surplus money. How do you go about getting that for your client? There's two different procedures. If there are no other claims, if the homeowner is the only person with a claim to it, you can move straight for a motion to confirm the referee's report and disperse. If there's competing claims, if there are other lien holders, other people fighting for this pot, then it's a more drawn-out process. The first step is to bring a motion to confirm the referee's report and to appoint another referee, yay, to compute and to work out who gets what of that pot. The requirements for surplus money proceedings are set out in RPAPL section 1361. Firstly, you need to file a notice of claim to the surplus monies, and you need to do that before you move to confirm the referee's report of sale. I've always found this section a little bit confusing. The timing to bring your motion to confirm the report can't be, you have to wait 3 months after the report of sale has been filed, but you're supposed to do it before 4 months. So you've got this little window when you're supposed to bring your motion to confirm. So really the best thing to do is if you've got a homeowner that's going to want to claim on the surplus money, file the notice of claim early, and if you think there's going to be competing claims to it, be ready to bring your motion really at the 3-month mark, because you want to get your motion in first before anyone else moves for it. Now, in practice, I would say don't get too bogged down by these timeframes. I've had homeowners come in months and months after their sale saying, I think there might be some money there and I think I might want to try and get it. And I've had no problem filing notices of claim and bringing these motions way past these deadlines. But you just have to be aware of them, because you might have somebody else moving for it before your homeowner even knows about it. So what do you need to do? It's quite a lot of documentation you need to get ready if you're going to bring a motion for surplus money. You need to get a certificate of claims from your county clerk. You might need to get a limited title search. It does specify that that is required, but again, I can talk more about that. You're going to have to prepare your affidavit in support of the motion. You're going to have to identify all the lien holders and anybody that's appeared in the foreclosure action. It's really just a factual affidavit. You know, you're taking the court through, there was a foreclosure action, you know, the property went to sale, your homeowner owned the property at the time of the sale, the surplus money was deposited, and that, you know, you state why your homeowner's got the claim to it. You need to get a copy of the referee's report of sale. You need to get a certificate of deposit from the county treasurer, just confirming the money that they hold on deposit, and copies of all notices of claim that may have been filed by anybody else, and all notices of appearance in the action. So really you do have to do quite a lot of kind of fact gathering and getting your paperwork together. Prepare up a draft order and get ready to serve out everybody when you're bringing your motion. If you're doing a surplus money, if you're filing a claim for it, I would say just try and keep your application as simple as possible. You have to identify all other lien holders, anybody that might have a claim. You really want to try and avoid having a referee appointed. It slows down the process and it's really expensive, because the referee is going to get a chunk of money for being involved. So if there are other, if you've got some small money judgments that are sitting there, contact those lien holders. Try and negotiate and settle it out with them. These people are probably not going to be bringing claims. They're probably not going to initiate the claim themselves for the surplus money. They may not even know it's there. I've certainly had quite a lot of success just settling with them. Get a stipulation in support, and then you can exhibit that. You can add that into your motion papers, and just like I said, keep it simple for the judge. If they see, oh well, okay, everything's all sorted, well then the rest of the money is just going to go straight over to your homeowner. Also, check with the judge before incurring the cost of the limited title search. Again, when I've spoke to judges clerks and explained the motion that we're going to be bringing, they've said, yeah, don't bother doing that. That's just an unnecessary expense for your homeowner. As long as in your affidavit you clearly identify everything else that's on record there, that's a cost that you can sometimes avoid. Again, I'm speaking from Monroe County. I can't really talk to any of the other counties, but it's worth making the call. And just be sure to serve out everybody. Anybody that has a potential claim to that, if you serve them out then and they don't respond, then again, more likely that your homeowner is going to get that whole pot. I've had success doing that too. So serve everybody, don't cut corners, and hopefully you'll get there.
Okay.
Judge order.
Oh,
sorry, Jim.
Sorry. Go right ahead.
I was just going to say, once the judge signs the order, you need to get a couple of certified copies, file that with the Treasury or the office that's holding the funds. They'll process a cheque. They'll deduct their fee, 2% of the amount that's being held, and then you'll get a nice large cheque that you can give back to your homeowner. It's not their house, but they're always happy to get some money. So questions on those?
So we have a number of questions, so I'd like to keep in mind that we only have about 15 minutes left, so we're going to try to limit these questions a bit. So if I don't get to you, I am sorry in advance. So first of all, what are CTCAs again?
Oh, sorry, consents to change attorneys. I kind of jumped over that a little bit. Just be aware that you could serve out the attorney that you think was representing. They filed a notice of appearance. You serve them. Well, there might have been a consent to change attorney that was filed later on. That's really common because they transfer these things left, right, and centre. So just make sure that you're serving out the correct attorney of record. You might have to pull the court file. You might have to have a look.
Okay. So one question is, do you know who gets the money if no one claims the funds?
I believe that just gets swept up into the state somewhere after, don't quote me on this, it might be 3 years, 5 years, there or thereabouts.
Okay.
It's not held indefinitely, for sure.
Yeah, I know that I think it becomes part of the town's budget in some way. They sort of, it's not too much that happens, but there's some. So where do you check for claims? Is there some place that you can check for claims, and is the homeowner required to be served with any claims?
No, you don't have to be served with claims. When you file a claim, you just file it at the county clerk's office. So that's where you're going to go to check whether or not any claims have been filed when you hit that 3-month mark.
And if the IRS has a lien, does the IRS also need to be served?
Any lien holder has to be served if you're bringing a claim for surplus money. Regardless of whether or not they've filed a notice of claim, any junior lien holder, anybody, you're just going to have to serve everybody.
And so this would be helpful for perhaps pro se homeowners as well. Is there a specific notice of claim form to help the homeowner claim the surplus monies?
Yes, there is. And one of the counties, I think it's, and I can find this out and I can send it to you, Becky, I think Erie County might have some sort of pro se forms available online, or some standard forms to use for homeowners that are trying to do this themselves.
Okay. All right, so there's a couple of other questions that these might be better answered offline. So in light of time, let's move along. Marlene, I believe you are next. So Fiona, let's change the presenter. First of all, Fiona, thank you. This is a lot of information, and I know that there's a lot more questions still out there. So if folks have questions later on, we are going to have a screen with people's contact information, and I am, without totally the permission of the presenters, I I believe that they are offering to answer questions offline as they come up. But in the meantime, Marlene. Marlene, are you there?
Sorry, I was muted. Hello, everyone. I'm going to be covering the two methods of post-foreclosure evictions, writ of assistance and summary proceeding. This is all after the foreclosure judgment and the sale. So this writ of assistance, it comes from the common law, but it has been codified in the Real Property Actions and Proceedings Law, Section 221. So whenever the foreclosure judgment directs the delivery of the property, it gives the Supreme Court the authority at its discretion to issue an order directing the sheriff to put the new owner or the new holder of title into possession. So if the prior homeowner are still in the property after being exhibited the referee's deed, the new owner can motion the court under the same caption of the foreclosure action for a writ of assistance. The writ is issued at the discretion of the court, so it could be, there's a possibility that it could be denied. It is also possible for to hold the prior owners in contempt if the judgment, the foreclosure judgment directs delivery of the property as disregarding the foreclosure judgment or the order. So some of the requirements to obtain a writ of assistance, the basic due process requirement is that the parties sought to be removed from the property have to be named in the foreclosure action. I usually represent tenants in foreclosure, so that issue comes up mostly with tenants. Not quite sure homeowners would be in the same position. Prior to issuance, there has to be the exhibition of the deed and a demand of the prior homeowners to vacate the property. There is really no requirement that a notice to vacate has to be served for a writ of assistance, but the demand is usually specified in the judgment foreclosure. Usually attaching the deed to the notice of motion demanding possession would suffice. Two of the things that you want to watch out for is that the service, the exhibition of the deed to the prior owner, it has to be on the homeowners, not their attorney. So substituted service may be insufficient for it to constitute exhibition. So two of the things that could arise. So to stay the writ of assistance, foreclosure is an equity, is a suit in equity. So homeowners may move by order to show cause or file a motion in opposition for the writ of assistance to stay the execution. And it's equitable authority. The court can do, quote, do which ought to be done, that which is fair under the circumstances of each case. So the court will look at the relative equities in the particular case. Some things, at least again, my experience is mainly with tenants, but that could apply for prior homeowners as well. The court could take into consideration sickness, or in one case, the court took notice of the shortage of housing in the area and granted a stay of the writ of assistance. Because it is a suit in equity, unclean hands doctrine does apply. So I did find a case where the motion for the stay was denied due to the prior owner's affirmative actions of delaying and impeding and the bank to exercise its right under the note. Other things in bringing a motion in opposition is claims of fraud in the procurement, irregularities in the sale, or any other claims, rights. All of those are deemed precluded as a matter of res judicata of an unappealed foreclosure judgment. The second method of eviction and post-foreclosure is to commence a summary proceeding under Article 7 of the RPAPL. Generally, these are going to be holdover proceedings where you're only asking for the possession of the premises. For tenants usually, they could also be evicted for payment of non-payment of rent. But for homeowners where there is no landlord-tenant relationship, these proceedings can be commenced under RPAPL 713, and specifically Subdivision 5 provides the authority where the property has been sold in foreclosure. Some of the requirements for that, it's a predicate 10-day notice to quit or vacate. That 10-day notice has to be served in the same manner as the notice of petition, and petition is required on the RPAPL. And the notice it has to name the persons in possession, describe the property to be recovered, and generally it has to be clear and unequivocal. The exhibition of the deed in this case is it only requires that a certified copy of the referee's deed be attached to the notice. So I'm going to discuss some of the common defenses in summary proceedings that I've seen. So first we look at the predicate notice for any defects. A defective predicate notice deprives the court of subject matter jurisdiction. An example is a notice that does not, that incorrectly states the address of the premises to be recovered. If a notice was not served or a deed was not attached to the notice, that also can deprive the court of jurisdiction. I put down failure to serve the notice pursuant to RPAPL 735. Service of the notice is usually not considered a jurisdictional defect, but that's something that you could bring up for negotiation tactics. And also another subject matter jurisdiction issue would be if the proceeding is commenced before the 10-day is up. Okay, other common defenses are improper service. So those are pretty run-of-the-mill. The RPAPL 735 allows for personal service on person or of a person of suitable age and discretion, or nail and mail. While it's less strict than the CPLR, you only have to make a reasonable application or attempt at personal service, or you can leave the papers in a conspicuous part of the property. In that respect, in terms of due diligence, is not as strict, but it is strict. You have to have strict compliance with the statute. So if service is one of the main issues that I see is service is not complete. Where there is substituted service of the notice of petition and petition, service is not complete until the affidavit of service is filed with the court. And that's usually one of the big issues that I've seen. Also, the next one is on timeliness. RPAPL requires that the notice of petition and petition, the service, be complete within at least 5 days, but not more than 12 days before the return date. And again, that's an issue in substituted service when service is not complete until that affidavit is filed. So you start counting that 5 to 12 days from the time of filing of the affidavit. And another issue you may see in post-foreclosure evictions is the improper petitioner. So RPAPL 721 provides a very exhaustive list of who can bring one of these proceedings. In essence, it's only those who have possessory right to the property. Specifically, Subdivision 3 provides that the purchaser, upon execution or foreclosure sale, can maintain a summary proceeding. Issues that may arise are receivers in foreclosure. For them to be able to maintain an action, summary proceeding, they have to be specifically granted the power to do so. Also, an agent of the title holder is not a proper petitioner, so someone who has power of attorney will not be a proper petitioner, and the proceeding can be dismissed. And finally, the other things that are not necessarily going to dismiss the case, but it's something that you can use for negotiations, asking for more time. Their defective verification, the petition has to be verified. Sometimes it's not, very rare, but mostly is the language does not comply with CPLR 3020. So we look at that to make sure that it complies. Also, where the petitioner is a corporation, so if the title holder is the bank, CPLR requires that a corporate officer verifies the petition. The attorney for the bank can verify it, but there has to be a statement of the reason why the corporate officer did not sign or verify the petition. And finally, there are required pleadings under 741 that have to be in the petition. The most important one that you would see is the property description. Make sure that that's correct, and the pleading of the interest in the property for both parties. And now I get to take questions.
So I think in light of the time frame and just being respectful of everybody, I think let's move along to Lynn's section, and then hopefully, Lynn, is it okay if you stay on for maybe a few minutes past 1 o'clock? Just to remind everybody, this is getting recorded as we speak, so if you have to step off, we understand. Feel free to come on back in a week or so. We should have this posted on the portal later on. So if that's okay with the speakers.
Sure. Hi, everyone. It's Lynn. I can breeze through quickly as well.
All right, I'm handing it over.
Okay, so are we there? Everyone sees my screen?
Yes, we do, Lynn. Thank you.
Now I just have to find that little arrow on the left to click it. If I hit enter, will the pages advance? No.
It will, and you know what? While they should, if you hit click enter.
Yeah, I'm entering, and they're not advancing. Oh, I'm so sorry, guys. This happens.
While you work out that, I'm going to quickly say out for people who have to see the CLE code for people.
Here we go. Sorry. Yes.
Oh, I can't seem to find it, actually. Michelle, can you read out for us the CLE code? I can't seem to find it at this very second.
Sorry, I was on mute. The code is going to be E is in Edward, V is in Victor, T is in Tom, 642, and I'll put that in the chat. So that's EVT 642.
Perfect. All right, thank you. All right, go ahead, Lynn.
Okay, so there was a little duplication between Marlene and me, so I will try to go quickly through this. But just in general, summary proceedings, most of the defenses are going to be technical. It is a creature of statute, because it's in derogation of the common law. Strict compliance is required. So there's a lot of litigation in housing court over technical defects. But there is one area of substantive defenses that can be litigated in housing court, which I will get to shortly. So Marlene already talked about the writ of assistance, and this is the basis in the RPAPL for the summary proceeding. She already discussed. There is a defense around improper signing of the notice to quit. So the notice to quit should be signed by the petitioner, but sometimes those notices are signed by agents. And if it's signed by an agent, it has to be accompanied by a power of attorney. So in foreclosures, as we know, servicers have powers of attorneys from banks, but those powers of attorney usually only address the servicing of the mortgage loan and don't address what happens after foreclosure. And so one case has held that that power of attorney was not sufficient to authorize the servicer to sign the notice to quit on behalf of the petitioner, who was the lender. Also, in the RPAPL summary proceeding, the referee's deed must be exhibited. There is an appellate term second department case that says when the deed, yes, so the deed, as Marlene said, is attached to the notice to quit, but when it's exhibited in that fashion, serving the notice to quit by nail and mail is not going to suffice for the requirement of exhibiting the deed. There was one judge who really, in Suffolk County, who hated that decision, and there's a long case where he talks about how wrong it is, but it is binding in the second department because it's the appellate term. There have been 2 lower court cases that have held that even service on a person of suitable age and discretion is insufficient for the exhibition of the deed requirement. So the law appears to be right now that the petitioner has to actually personally exhibit the deed to the respondent. There was one case in Brooklyn where the petitioner, a member of the petitioner LLC, personally exhibited the deed to the respondent's son. There was a commercial holdover. The son was deemed the agent of the respondent's store owner, and that was sufficient to satisfy the requirement that the deed be exhibited. Just so you know, there is a provision that requires notice in a summary proceeding. If there's a summary proceeding brought by the purchaser at a foreclosure sale, the purchaser has to give a notice to tenants that gives them the right to occupy for an additional 90 days or for the duration of the lease if it's greater. But just know that the former owner or mortgagor is specifically excluded from the statutory definition of a tenant, so they don't benefit from that provision. So here's where it gets interesting. You can actually litigate defenses relating to title in a housing court case. So because RPAPL 743, the answer may raise any legal or equitable defense. Housing court is a court of limited jurisdiction. It lacks jurisdiction to issue a declaratory judgment. It lacks jurisdiction to adjudicate any affirmative claim involving title, but if you're issuing on the basis that petitioner doesn't have good title, that issue may be litigated in housing court, and the determination of the defense in housing court has res judicata and collateral estoppel effect like it would in any other court. So these are some examples of title issues that have been litigated and determined in housing court: adverse possession, constructive ownership by virtue of some kind of constructive trust. There was a case involving gaps in chain of title where the conveyance excluded some of the heirs, and therefore the heirs were tenants in common with the petitioner landlord. As someone asserting the right to a life estate, these have all been litigated in housing court. None of them involved foreclosure cases, but here's a case that did involve a homeowner who remained in possession after a judgment of foreclosure and sale. The homeowner ended in the foreclosure action because this was a case involving deed theft, and so it was the straw buyer who was the defendant in the foreclosure action because it was the owner of record and the mortgagor. So in this case, there had been a default judgment, and the respondent in housing court was moving to vacate it, and the meritorious defense alleged in support of that motion was that she had lost title under a deed theft, that the deed was forged, and the petitioner therefore did not have good title. And the court held that that was a good defense. It was preserved because the respondent in the housing court case was not a defendant in the foreclosure case. And, you know, the law is a forged deed is void ab initio, and so if that deed was void, then the owner, the purported owner, didn't get good title. Now, the lender was not a party to this case because the petitioner was not the bank. The bank didn't buy the foreclosure sale. The petitioner was a third-party bidder. So if the respondent were to prevail on that defense, it wouldn't affect the mortgagee. And so then, you know, if the deed were voided, that mortgagee would probably come into the picture at some point and claim that they were a bona fide encumbrancer for value. And for those of us who've litigated deed theft cases, you know, if you can't get rid of the mortgage, you pretty much lose the case. So the takeaway, if your client, homeowner, was not named in the foreclosure action and they were a victim of deed theft, they can litigate that case in housing court. If they were named, the issue is probably res judicata, although this is a little complicated. New York doesn't have a compulsory counterclaim rule. The lender is suing. The claim is against a third a non-party, the claim would be against against the defended homeowner, and sometimes you might need to implead third parties. So I'm not prepared to talk about collateral estoppel res judicata today, but just know that if your homeowner was named in the foreclosure action, their rights are probably foreclosed on. They were probably required to assert any claim of deed theft or equitable ownership in that foreclosure action. But usually victims of deed theft are not named as defendants in the foreclosure case. The bank would not be affected by a housing court judgment, as I said earlier. And then just, if you are representing somebody who was a victim of a deed theft, you don't want to wait to housing court to litigate that claim because it is an inferior forum. You don't get discovery as of right. There's a huge volume. The judges are probably not all that friendly to the claims. They probably don't want to really be bothered with them, and it's just not the ideal place to litigate. Okay, one final note, the banks, as we know, are kind of sloppy in their foreclosure litigation, and that transfers over to housing court. So here's a case where the lender was the bidder at the foreclosure auction. They brought a summary proceeding to evict the occupant, but the law firm didn't notice that the property had actually been sold before they brought the holdover, and the law firm Druckmann was sanctioned $3,000. So I think I did that pretty fast. That's all I have. And here's all of our contact information, and I'm going to turn it back over to our presenters. But I think I need to change presenter button. Do I click?
Nope, you can leave it exactly right there.
Leave it. Okay.
You can just watch it. Yep.
Okay, there we go.
Don't worry.
Sorry.
Okay, so a couple of things. First of all, there are a number of questions rolling in. Some of them I understand, and some of them I didn't quite catch at the minute that they asked the question, so the context is a little skewed for me, so I apologize in advance that I don't get it right. But first of all, Fiona posted in the chat box. See, actually at the moment everybody can see Lynn's dashboard where it shows something similar to what you have, and there's a chat function in yours, and it's a website for the Erie County forms that she mentioned in her presentation, so feel free to utilize that. If you do have a case that you can use that as a good resource. Okay, so there's a couple of questions. Let me see if we can get through some of them. But first, if people again have to come off, thank you so much for your time and your attendance. And again, this will be posted later on in the portal. So let's move along. So I don't know, maybe Lynn, you might know the answer. The rest of us are all kind of upstaters. But who keeps the deposited money in New York City where we don't have county treasurers?
I don't know. There have been, I don't recall a case of surplus, honestly, but yeah, sorry, I can't answer that question.
Okay, fair enough. I thought I would just ask. So let's see.
No problem.
Is it possible for the bank to request possession as part of the foreclosure proceeding itself to take effect upon the sale and thereby avoid the need to bring a separate eviction proceeding?
Yeah, that was RPAPL 221 that Marlene and I both mentioned. The judgment has to direct delivery, of possession in order to utilize the writ of assistance. If the judgment doesn't specifically direct delivery of possession, then the lender has to bring a summary proceeding. But otherwise, they can just make a motion within the foreclosure case.
Okay. And actually, somebody in our audience actually answered the previous question about who holds the money in New York City, and the answer is New York City Department of Finance holds the surplus funds in New York City. So, Bruno, thank you. Another question, I'm going to try to piece it together, so I apologize it'll be a bit choppy. So we're wondering if there's a way to challenge the requirement for the limited stub search, in tax foreclosure surplus cases. I'm not sure that I'm helpful in this question. I'm so sorry, Jordan. Maybe write that question out for like questions for dummies like me to try to answer your question in a helpful way. If you can rewrite that, that might be a bit more helpful for me. I'm sorry, I'm not piecing it together well for you. So if that comes along, or in addition, if there's questions that you asked that we didn't answer quite right, or you're still looking for some additional follow-up information, again, Fiona, Marlene, and Lynn, they have graciously posted their contact information here for you. I believe that they are willing to answer some of those questions as best as they can, of course. And for the rest of you, thank you so much for sitting in today. I hope this was helpful. It certainly offers some insight into what your homeowners may whether they know it or not, are going to be facing going down the road. So I think it's helpful.
Rebecca, can I just add one more thing? I'm sorry, it's Lynn. I forgot to mention that in a housing court case, the court has discretion to give the respondent time to move up to 6 months. And there's some case law that allow courts to go even beyond 6 months. So I just forgot to mention that people will have time to move when it comes to that.
Okay. There's a question about the address for sending your notices of appearance, or your certificate of attendance requests and your CLEs. So the email address is in the chat box. It's mpeterson, P-E-T-E-R-S-O-N, @empirejustice.org. But that's in the chat box if I went too quickly for you. Hopefully we've covered everything else as well. Fiona, Marlene, Lynn, thank you so much. This is extremely helpful. And to everybody else out there, enjoy your day, and I hope this was helpful to you as well. Have a good day, everybody.
Thank you. Bye-bye.